Appeals, Division 1 is now in session.
Please be seated. Thank you for being here today. We're here on our case 1 CV140584. FC is Soto versus Kearns. Each side will have 20 minutes to make their argument. Appellate, you may reserve any portion of that time for rebuttal. You'll have to keep track of your own time, and there's a clock at the podium for that purpose. We will be recording the argument today, both in video and audio. It will be on YouTube in a couple of days, so you can watch that when it comes out. Because we're recording the argument, please identify yourself and your client when you begin the argument. We've read the briefs, we've conferenced the case, we've discussed it, so we're familiar with the law and the facts. So when you begin your argument, just go ahead and launch right in. Counsel, you may begin.
Thank you, Ed. Good morning, Your Honors. May it please the Court, my name is Virginia Cruz. I practice with Paul Lankowski at the law offices of Paul Lankowski, and our client in this case is the appellant, Christina Kearns. And I will just skip over then the statement of the case unless the Court has any questions about the background. The main reason, Your Honors, we brought this appeal is that Ms. Kearns is seeking a remand from this court with a finding that the trial court in this case abused its discretion throughout the trial. Ms. Kearns and her ex-husband, Mr. Soto, were self-represented parties at the two-day hearing last July. And at the conclusion of the second day, the trial judge placed on the record his findings in this case. The first thing I'd like to focus on as far as our position of how the trial court abused its discretion is the trial court in its July 2014 order failed to consider all the relevant factors as required under ARS 25403A. I know the appellee in their response to our opening brief contends that the court didn't specifically go through all 11 factors in 25403A because it made a finding that the circumstances had not substantially changed since its prior order. But the language that the appellee relies on, if the court takes a look at IR 242, which is the minute order dated July 30th, 2014 from the last hearing, when the court refers to adopting its findings, it refers specifically to the second page of its order, the prior order, which is IR 170. And if the court looks at the second page of that September 2013 order, you'll find that the only thing the court is referring to in July when it refers back to the September order is its jurisdictional finding and its general language that it's making a decision in the best interest of the children. It's not the trial court adopting its findings from the prior order of the 11 factors. And in fact, if you look at the prior order from September of 2013, the trial judge at that time, which was the same judge throughout, did not make findings as to all 11 factors even at that time.
Is there any law, though, that requires findings as to all 11 factors? Isn't the judge required to determine which factors are relevant? and then make findings on those?
Yes, I would agree with you, Judge Schwan. The court is only obligated to specifically make findings regarding all relevant factors. But in this case, we would argue that most of the factors of 403 did apply in this case and should have been specifically analyzed and specific findings made on the record regarding this case. The court really just made a cursory review of the factors, both in September of 2013 and especially in July 2014, where this is appealed from. And if I could, what I'd point to is that the court in its July 2014, when it mentioned specific factors of 25403A, only mentioned A1, 2, 3, and 5, and didn't go into great detail about the findings from those, and did not make any findings related to 4 or 6 through 10, and did not mention 11 at all. And I would concede that a few of the factors would not apply even if the court had mentioned them.
Right, I mean, there was no agreement here, right?
Correct.
So 9 is irrelevant.
Correct. And I would agree that 11 was not brought up as an issue at all.
And
But
what about 4? Is there
I think, I apologize.
evidence as to the wishes of the children that the judge failed to consider?
Well, the court didn't give any deference to the wishes of the children. The court never interviewed.
What was the evidence on that point?
There was none because the parties being self-represented, neither side asked for an in-camera interview under Rule 12 and the court on its own motion. But I think the error.
Let me ask you this, though. Had the evidence rules been invoked?
No, not by the self-represented parties, no.
And so some of the case law that you referred to in your brief was decided before the new family court rules, or I say new, they seem new, new family court rules that presume that the rules of evidence won't apply. Did the parties testify as to the wishes of the children, even in a hearsay fashion?
No, Your Honor.
Okay. So can we really reverse the judge for not making a finding if there's no evidence?
Well, I think the error on the part of the court, especially with self-represented parties before it, is not even making the inquiry into the parties, because they each testified at all of the hearings, or on its own motion seeking to interview the children. At the time of the hearing in 2014, of the 4 children, their ages ranged, I apologize. At the time of the last hearing, the oldest child was 13. So of the 4 children, I believe at least the 2 oldest, 11 and 13, if the court had made the inquiry, would have had something relevant to say. So.
But do you believe that we should hold that the court is required to make an inquiry like that? I mean, in family court cases, courts ask all kinds of questions they might not ask in cases with juries, for example. But, I mean, can we say that a court abuses its discretion when it doesn't ask for hearsay?
I would say yes. And I say that because it's a specifically enumerated factor that just legislators put in under 25403A. I mean, 4 is there, and the indication is if the child's of a suitable age and maturity, that the court should take into consideration their wishes. And the problem I have in this matter is it wasn't even addressed by the court. And the court would have had the easy ability to, even if it was just asking the parties during their testimony about the children and their desire. And it could have, I suppose, gone the next step and on its own at least interviewed 2 of the children. I mean, this is a case that it's not just one hearing, half of a day. This is a case that was with the same judge from the onset of the divorce, with the final decree being early 2012, and then multiple post-decree and modification requests. So,
it would be kind of a significant departure in the law, though, to place upon the court a burden of asking specific questions, wouldn't it? Beyond its jurisdiction, it's still an adversarial process.
yes, Your Honor. But in this case, I think with the parties being self-represented, the court had no problem involving itself in asking questions in other areas. And I don't think, in light of that background, that a few questions to either side would have been burdensome or added much to the hearing in this case, as far as time. Of concern to us, going back to the factors, is that the court in July of 2014 did not go into depth with its analysis of Factor 5 either. When the court made its order in September of 2013, it focused on Factor 5, finding that the court had concerns about mother's mental and emotional health at that time, but those concerns had diminished over time. And the court, when it spoke about that factor by July of last year, it focused on, and you can see from the record, it focused on mother's physical appearance at the time. So there was no evidence at the hearing, either day of the hearing in July of last year, that mother had any ongoing mental or emotional issues that the court needed to be concerned about. The court did seem to focus unfairly on mother's self-admitted possession of a medical marijuana card, and rather than the court asking about if she was compliant with any order or any prescription that was given to her, the court focused on using language, finding out in its own interest if she smoked pot at all, and kind of ignoring the fact that she had a valid medical marijuana card at the time.
The court base its decision on any lawful use of marijuana?
No, the court made a vague reference, both in the record and then in the minute order, about, it was more in the record, about mother's frail appearance, and
Well, how does that connect with marijuana use?
well, there was no evidence of any other issue with mother during that hearing. The only thing that came up that the court focused on was concern about marijuana use. So that's why we thought the court had unfairly focused.
I would agree with you that being skinny is not a disqualifier for parenting time, but is there any indication that that formed a basis for the court's ruling?
Not by the court's wording, but in its decision, but the court's questioning to Ms. Kearns in the hearing was an unfair focus on her marijuana use by referring to it, did she smoke pot at the time? Was she smoking pot? Those sort of things. So, and again, in the language of the decision, there wasn't a specific mention of her drug use, but there was nothing else mentioned by the court.
Even legal drug use, though, can be a factor, right? I mean, if one has a recurring prescription for narcotic painkillers and is legally using them all the time, it can impact parenting ability.
It can, but our problem with the court's reference to it was the language used by the court and just referring to it as pot use without any further questioning or attempting any in-depth.
I don't understand. I mean, you mean that because the court referred to marijuana colloquially?
Yes, Your Honor, and the court never had a line of questioning or tried to evoke any testimony as to what her use might have been or how often or anything like that, but just sort of categorize it as, well, you smoke pot, so that must be a problem. So. Your Honor, I'd like to move on, unless you have any other questions about the 403 factors, just briefly onto the 25-403-01B factors, and the court failing to analyze those factors at all in the July 2014 decision. Again, appellee responds in their brief referring to the July order encompassing the prior decision from the court, but when you look at the language quoted by the appellee, and that's on the very bottom of page 1 from the July 2014 order IR 242, the court makes a statement that it's found very little has changed since its last decision, and the court's going to adopt a majority, if not all of its decisions, with the following provisions. And then it goes into detail into the jurisdictional findings, and then it makes limited findings, again, that I already spoke about 25-403 and those 4 factors. But there's never a mention in the July 2014 order of any of the factors under 25-403-01B. And when you look back at the September 2013 order, the court at that time only addressed the first 2 factors of 25-403-01. So I guess we're arguing that the court in July of last year did not specifically adopt its 25-40301 findings from September of 2013. And even if you found that it had, it only addressed 2 of the 4 factors at that time.
When hearings happen so close together, though, is it reasonable to say that the evidence the court considered and made findings on should be completely disregarded?
I don't think they should be completely disregarded. But again, I have a twofold issue with the July hearing. One is that the court didn't specifically adopt its findings from the September before under 25-40301. And the other part is, even in September, the court didn't make specific findings under all the factors of 25-40301. This would have been a different case, and maybe not even much before this court, if the trial court had been more detailed in its language, if it had intended to adopt all the findings it made before, and just with a few exceptions of some things that had improved or changed, that would have been fine. But the court instead just went through even less factors this time around without specifically adopting all of its language or adopting its findings from the September before. So, and the court, and I'm sure you guys, this court was able to recognize from the procedure of this case and also from the language of the minute order, in September of 2013, the court did invite Ms. Kearns to file after January of 2014, which is of course a shortened time than usual, if she could prove to the court within that very short window that she had gained stability in housing and other aspects. And so she did that by April of 2014. So I would completely agree, it's a very short window, much shorter than most cases. But I think at that time, in September of 2013, it was the trial court, who again had been with these parties and their situation for a few years. It was the court's recognition that things might evolve kind of quickly, and had agreed to shorten her time.
Almost a continuation of the same hearing, really.
It really almost was. Especially the way the trial court treated it. One of the issues we had with the trial court was from our view, its unilateral assistance to Mr. Soto versus Ms. Kearns. If you look at Ms. Kearns, what she was allowed to present as evidence or testimony versus the assistance that Mr. Soto received, Ms. Kearns did not present much additional information for the court to be able to consider. And again, that's one of the issues we had with the court abusing its discretion, and that was in the unilateral assistance given to Mr. Soto as far as helping him, kind of over the top, helping him as a self-represented party enter exhibits into evidence. And on the record, it's very clear during the hearing that the court had to have been taking notes while Mr. Soto, which is of course expected, but notes to the degree of detail that when Mr. Soto attempted to enter an exhibit and he was unsuccessful in grasping the concept of foundation and getting exhibits properly admitted, the court had taken such detailed notes that then it was able to go back to 4 specific exhibits when Mr. Soto testified and bring those up, and the court asked the questions to lay the foundation, and then the court on its own admitted those. And those were detrimental to Ms. Kearns because they addressed specifically, they were police reports that had to do with complaints that Mr. Soto had made about Ms. Kearns and her care of the children and the state of her vehicle. And when Ms. Kearns tried to bring in her own E-111 to combat that and rebut that and show that the police had sided with her as far as that situation, the court offered her no similar assistance, and ultimately that exhibit was not before the court to review. And I'm going to reserve probably the last 2 minutes for rebuttal to the appellee, but I did just want to end with saying at this point that Ms. Kearns, the main reason that she is before this court is to have her case remanded back. I mean, this is a mother who has not had overnight visits with her children since the time of the divorce in early 2012, and this is a mother who has not been awarded even the standard parenting time under Mojave County guidelines since 2012. Thank you.
Thank you, counsel. Yes, please.
Do we need to oil that chair or something, Counsel?
think
It's
so.
Squeaky's chair. I think I've heard in a long time.
I would pick it too. Good morning, Your Honors. My name's Heather Wellborn, and I am a private attorney from Lake Havasu City, and I represent Mr. Mark Soto, who is the appellee in this matter, and I'm honored to be here. This is my first time arguing in front of you, so I appreciate your patience with me while I'm working
Welcome.
through this.
Welcome to the Coliseum.
Thank you. I did take pictures. First of all, I would like to address the standard of review that's applicable in this matter. I think that we definitely can't forget what we're dealing with here in terms of what the proper burden of proof is. And here, I know the court has read the briefs, but I just want to reiterate that the court here reviews the family court's decision regarding custody in terms of an abusive discretion error standard. Secondly, we're not here to reweigh the evidence. I know that there was quite a bit of information presented about the facts of the case, and I think that looking at the history of where Judge Bartlett started with this case back in January of 2012 when he had entered his initial order, he awarded my client, Mr. Soto, sole legal decision-making back then for very solid, cogent reasons. And he did award him sole legal decision-making in the mother's supervised visitation. As Judge Swain had indicated, this case has been, in essence, a continuum where the court has been patient with seeing progress with the mother, and when we do get to the July 2014 order, which is IR 242, the court further pushed things along, but it wasn't comfortable with fully changing or modifying the prior order that had been in existence. The court did an IR 70, which was the prior order that was from September 23rd of 2013. The court did go through a very specific analysis of all of the factors, and it is the appellee's position that the court specifically indicated in its July 2014 order that it was adopting its findings that were from the prior order of September of 2013. It hadn't even been 1 year from the prior hearing where evidence was presented, and then we're back in court again on now additional issues that had been presented. And again, the court, going back to 2012, had seen evidence and testimony of years of substance abuse, mental health issues, the mother continuously putting the children in dangerous positions where they were once, they had to be hospitalized because of being subject to carbon dioxide poisoning. There was evidence that was presented of my client attempting to protect the children. The court even had to make specific orders that the mother wasn't to smoke around the children, and the mother wasn't to have the children riding in the back of pickup trucks. There were just decisions and things that the mother, bad decisions, parenting decisions, that the court had seen over the years of this case, and the court just didn't find that the evidence presented was significant enough and that the mother had met her burden of proof to change the current order that had been in place back in September of 2013. Specifically, the mother did have the burden of proof, which the burden of proof is to show that there had been a substantial and continuing change in circumstance from the prior order that had been entered. And the court here specifically found that the mother had failed to meet that burden of proof. And I think here the court should affirm affirm the court's decision because the mother had failed to present substantial evidence that supported the court changing that decision. With regard to the 25403B factors that the appellant had argued, here, Your Honors, the same argument would apply that specifically in the order of IR 242 reference back to the IR 170, which is the September 20, 2013 order, which uses similar language. Specifically, the court still finds that joint legal decision-making authority is not an option for this court because of the inability of the parties to get along. That similar language here, where the court considered on the third page of its September 20, 2013 IR 70 order, specifically states that the court a precursor to the analysis of the children's best interest, and because the parent's inability to reach an agreement, the court considers the 25403.01, and the court found specifically that neither party can cooperate. So I think just because the court didn't specifically state the statute, the language is there indicating that he did consider the statute, and he found that the parties still do not get along, and so ordering joint legal decision-making was not an option for the court. So I think under the strict...
Is that really the question, though? And if they got along, they'd probably still be together.
That's correct, Your Honor. I absolutely...
Have joint legal decision-making.
I absolutely agree, and I'm specifically just addressing the issue that the appellant brings up with regard to 25403B, where she tries to argue that the court doesn't even address that factor. However, I believe, and my client believes, that the court did address that factor because of the language that is specifically identified on page 2, even though the court may not have cited the specific statute.
But did it consider the right things? I mean, the factors governing whether there should be joint legal decision-making aren't whether the parties like each other, right? But whether they're able to participate in joint legal decision-making in a way that's going to work for the best interest of the children. Those are two different questions.
That's definitely true, Your Honor, and I think the evidence that's been presented to the court shows that the parties had attempted to cooperate regarding school decisions and regarding extracurricular activity decisions, and there were definitely differences of opinion in terms of vaccinations, and those are all issues that were testified to at the trial, and all issues that the parties couldn't agree on and couldn't get along with in terms of coming to a decision. I think that's part of why the court continued to find in this further hearing that the parties are continuing to have this inability to co-parent and cooperate, which is why I think he summarized it as that they're not able to get along.
And when it came to vaccinations, I mean, while I tend to agree vaccinations are a good idea, the court seemed to go off on a theory about vaccinations supported by popular discourse rather than the evidence. Does that concern you at all?
I think that the court isn't required to consider a case in a vacuum. I think that the court can consider information. I think the judge specifically stated in his ruling that things that he had read or that he had studied or that he opined as to how he came or how he knew what he knew and the information that he had, because it was information that he had researched. Maybe not specifically about this case, but I think that that the court can utilize its experience as a whole to come to a decision, and I think that his reasoning there wasn't flawed because of how he drew on the information.
Well, it's dangerous, though, isn't it? I mean, where do you draw the line? If the court had read a bunch of materials that suggested that moms are just generally better parents and decided in mom's favor, I'm sure that would concern you.
Absolutely. I think that where the court specified in that it had done research, and it didn't seem to be, seemed to be that it was information gleaned from a source that would not have been reliable. And so given the source the court felt was reliable, I think that makes my concern less, because the court drew from information that it gleaned from a source that it felt to be reliable.
What are your feelings about the comments on mother's physical appearance?
Again, Your Honor, I think that the court has had this case for many, many years. I think the judge also stated in the dicta that's part of the record that he has watched a progression in the mother, and he's seen her appearance as she's come to the different court hearings, and how there had been a significant history of substance abuse and mental health issues, and that the court found that given that history, her appearance that he had witnessed over the years still was something that was a concern to him. So I think that...
Is physical appearance an appropriate consideration for a family court judge? I mean, what if she has cancer?
I think that based on the totality of the circumstances, Your Honor, and the evidence that had been previously and currently presented to the court regarding the mother's substance abuse and her continued alcohol abuse, that was evidence that supported his finding, and I think the court can draw reliable or logical inferences from the evidence. That doesn't...
You have some reliable basis of scientific study out there that shows that smoking marijuana and drinking alcohol makes people thin?
I don't think that was something that was opined in the minute order, Your Honor, but I think that the prior history, again, that the evidence had been presented to the judge, where I believe there was heroin use, methamphetamine use, there was crack cocaine use.
But
that
no
was
evidence that was ongoing at the time of this hearing?
not that my client presented that I recall, no, Your Honor.
No allegation even that was going on at the time of this hearing?
Correct, Your Honor. I don't believe I saw an allegation to that regard.
Did the court make a connection between mother's frailty or thinness with drug use or marijuana use?
I think that the way that I read the court's decision was just that he had based his decision on the continuum of what he had reviewed in terms of the mother's appearance throughout the years, and that he still continued to have concerns about her appearance and her mental health issues that he felt were she was progressing, but the court still had concerns. I think that the court definitely did give the mother credit for the progress and the strides that she had made, and he did feel that she was making progress and was getting better in her situation, trying to create a more stable home environment, even though the evidence showed that she had been evicted and she was several months behind on rent, and she didn't have a proper vehicle to even transport the children. Even though those issues were still persisting, I think that the court still found and gave the mother some credit where she deserved it, in that she had been making progress, and I don't think that he based his decision solely on her physical appearance, although that might have been a basic consideration based on the history of what he had seen, but I don't think that was the only.
Was there evidence to support that any of these problems were ongoing, or was he just sort of eyeballing it?
I think that the evidence that was presented was my client's testimony about the concerns with the mother's behavior, and then also with regard to one of the witnesses that testified about the mother's behavior at a party that she went to, and some text messages where she had become severely intoxicated and promiscuous at the party, and that there was some heavy drinking involved and possibly drug use involved, but there wasn't. It was a speculative comment, so there wasn't any proof that there was drug use, but given she had been continuing to exhibit that same concerning behavior, and that was something that was brought into evidence, was something the court, I think, considered and did base its opinion on. Is there any other questions in that regard?
No.
Okay. All right. Now, with regard to what my client is asking here, Your Honors, my client's requesting that the court here uphold the trial court's decision. The trial court is held to be in the best position to determine what is in the best interest of the children, unless it appears very clearly that the trial court has mistaken or ignored the evidence or failed to properly evaluate it. And here, Your Honor, my client believes that, in line with the case that was cited by myself, which is Schultz v. Schultz, which was also affirmed, that here the court should also find that there's no evidence whatsoever in the record that there was any type of exhibition of any bias or prejudice on the part of the trial judge that was asserted by the appellant. And I want to speak to the issue with regard to the evidence that was presented, and with regard to my client being assisted or helped in any way with evidence. And I think the record shows that the court wasn't trying to create evidence or trying to create a record. I think the court was simply assisting both of the litigants in an equal vein. Both parties, if the court were to review the beginning of the trial minutes, both parties had issues with their exhibits. The court directed both parties to have the clerk deal with the exhibit issues. There seemed to be issues on both sides that the court was dealing with in terms of getting the evidence in. And I think the court didn't favor one party over another. There were certain exhibits that I think the court identified that needed some additional foundation, but I don't think that after reviewing the record that there was any issue with regard to my client being assisted in any way that was prejudicial to the mother. So I think in that regard that there was no error on the part of the trial court and that there should be no reason there why the court here should in any way reverse the lower court's decision. Here, Your Honor, again, I just reiterate that the lower court has in no way abused its discretion, that the mother, as the lower court found, specifically had failed to meet her burden of proof. She did not in any way prove that there had been a substantial and continuing change in circumstance from when the prior ruling had been issued. I think that the appellant tries to place the burden on the court to somehow create evidence or make evidence or require the court to ask questions to try and create a record. And I think that is absolutely not the court's position here. There is no requirement that the court should interview the children. There's no requirement that the court needs to ask questions to the parties about what their children feel. There's no burden that the court has to elicit evidence from the parties. That's what the parties' job is. They both decided to represent themselves, knowing that the court was going to hold them to the rules of evidence. And again, they had both been dealing with Judge Bartlett since 2012, and they knew his strict requirements, and they both, again, decided to wade in the waters in his courtroom without counsel, and the evidence rules were equally applied to both of them. And again, I don't think the court here had any burden
What are
to
his strict requirements? I'm curious. I mean, if the rules of evidence weren't invoked, what are the judge's strict requirements?
Judge Bartlett, I know he has his own local rules of court, which the mother did follow.
His own local rules?
Well, they're local rules of Mojave County.
Mojave County
yes,
local
the
rules. Okay.
Mojave County local rules that I do believe he was on a panel drafting. And there's a requirement in his courtroom that there is a judge's binder and that there be a certain amount of exhibits that are presented to the clerk and to himself. And the mother did follow those rules. She was aware of those rules. And Mr. Soto did not follow those rules, and that was one of the exhibit issues that I was bringing up in the beginning of the argument. But that in no way was used against either one of the parties in the presentation of their case or the evidence. The evidence wasn't disallowed, and I think there was actually one exhibit where the court did ask Mr. Soto if he had received it timely, and it was allowed and admitted into evidence. So I don't think there were any prejudicial issues on either side with regard to the evidence being presented to the court based on any violation of the local rules. Is there any other questions in that regard? Okay. So just lastly, again, Your Honors, I just requested the courts confirm and affirm the lower court's ruling that there has been no violation of the rules of evidence in terms of the way that the evidence was presented by either one of the parties and also by the rulings of the court, and I'd request the court affirm the lower court's decision.
Thank you, counsel.
Thank you, Your Honors. We go a little out of order, but I wanted to touch on the appellee's statement just briefly. When I believe it was you, Judge Schwan, that asked if the court had any evidence about the allegation of ongoing substance abuse. There was no evidence of a court-ordered drug test. There was no evidence presented of ongoing illegal substance use by the mother. The only evidence the court heard regarding alleged alcohol use of the mother did revolve around Mr. Soto's witness's testimony, which we complained of in the brief, where the court allowed in hearsay from that witness when a witness present in court was allowed to read text messages where another person unrelated to the parties had sent photos and was describing Ms. Kern's alleged activities at a party sometime before the hearing. So just so the court's clear, there was no direct evidence and there was no evidence by either of the parties that would have led the court to believe or given the court any reason to believe that Ms. Kearns had any type of ongoing struggle with any type of substance.
Well, maybe not substances, but given the lax rules of evidence, there was at least circumstantial evidence that stability might be a subjective concept in this case.
There was, I think, from past hearings, but I think sort of the problem with the same judge, and I know the decree was entered early 2012, but the filing is actually a 2010 filing. So Judge Bartlett, before he retired, had this case for years. So I know in the past, early on in the case, I would agree that there seemed to be concerns about stability of mother. I mean, one party is typically not granted sole legal decision-making of children, and the other party having supervised parenting time without, obviously, the court hearing and receiving evidence about concerns. But I think the issue or the problem in this case is that the court, with that background, kind of just kept the same mindset that mother had not progressed as far as she had by July of last year. The court, and not to beat the 25-403 factors, it's the last thing I'll say, but when the court makes the determination under 25-403 2, it did not give any consideration in its language in July 2014 about Ms. Kern's fiance, the stability of the relationship with him, the length of time in that home, and his influence on the children's lives. So again, we'd ask the court to remand this matter. The big concern is not that Ms. Kearns can't just petition the court again, but a bigger concern in this case is now Judge Bartlett, is retired. So the record, if it's not changed by this court, is what's going to stand, and the only thing the next court's going to be able to review in the trial level. Thank you.
Thank you, counsel. Thank you both for your arguments. We'll take this matter under advisement, and we will stand at recess, but we're going to stay on the bench while the next case comes up for our argument. Thank you very much.